Legal dictation, page number 9 and 10. Get ready, start. The issue centrally pertained to the necessity of having a driving license after advertising to various provisions. The court also delved into the fundamental concept of third party right regard being had to be nature of the beneficial legislation. The court observed the question as to whether an insurer can avoid its liability in the event it raises a defense as envisaged in subsection 2 of section 149 of the Act corresponding to subsection 2 of section 96 of the Motor Vehicles Act 1939 had been the subject matter of decisions in a large number of cases. The court posed the question as to whether an insurer can avoid its liability in the event it raised the defense as envisaged in subsection 2 of section 149 of the Act corresponding to subsection 2 of section 96 of the Motor Vehicles Act 1939. The court analyzed the language implied in subsection 2 of section 149, especially clause A, and after scrutinizing the same as referring to various authorities opined the proposition of law in no longer res integra that the person who alleges breach must prove the same. The insurance company is thus required to establish the said breach. The cogent evidence in the event the insurance company fails to prove that there has been breach of conditions of policy on the part of the insured, the insurance company cannot be absolved of its liability. Apart from the above, we do not intend to lay down anything further, that is, degree of proof which would satisfy the aforementioned requirement, in as much as the same would indisputably depend upon the facts and circumstances of each case. It will also depend upon the terms of contract of insurance. Each case may pose a different problem which must be resolved having regard to a large number of factors governing the case, including conduct of parties as regards duty to inform, correct disclosure, suppression, fraud on the insurer, etc. It will also depend upon the fact as to who is the owner of the vehicle and the circumstances in which the vehicle was being driven by a person having no valid and effective license. No hard and fast rule can therefore be laid down if in a given case there exists sufficient material to draw an adverse inference against either the insurer or the insured. The tribunal may do so. The parties alleging breach must be held to have succeeded in establishing the breach of conditions of the contract of insurance on the part of the insurer by discharging its burden of proof. The tribunal, there cannot be any doubt, must arrive at a finding on the basis of the materials available. No records in the aforementioned backdrop the provisions of subsection 4 and 5 of section 149 of the Motor Vehicles Act 1988 may be considered as to the liability of the insurer the satisfy the decree at the first instance. The present reference to the constitutional bench has its own complicity as the centropodal issue in its invitation of the interpretation of Article 239 AA of the Constitution evokes a host of concepts, namely constitutional objectivity, navigating through the core structure with the sense and sensibility of having a real taste of constitutional structure, the culture of purposive interpretation, because the court is concerned with the sustenance of glory of constitutional democracy in a democratic republic as envisaged in the constitution, and understanding the idea of citizenry participation viewed with the lens of progressive perception inherent in the words of a great living document emphasizing on the democratic theme to achieve the requisite practical goal in the world of reality. We may call it as pragmatic interpretation of a constitutional provision, especially the one that has the effect potentiality to metamorphose a workable provision into an unnecessarily and unwarranted piece of ambiguity. In such a situation, the necessity is to scan the anatomy of the provision and lift it to the pedestal of constitutional ethos with the aid of judicial creativity that breathe essentiality of life into the same. It is the of law that works. It is the requisite constitutional stimulus to sustain the fundamental conception of participative democracy so that the real pulse is felt and further the constitutional promise to the citizens is fulfilled. It gets rid of the unpleasant twitches and convulsion. To put it differently, the assurance by the insertion of Article 239 AA by the Constitution 69 Amendment Act 1991 by exercise of the constituent power is not to be renounced with any kind of rigid understanding of the provision. It is because the exercise of constituent power is meant to confer democratic, societal, and political powers on the citizens who reside within the national capital territory of Delhi that has been granted a special status. The principal question is whether the inhabitants or voters of NCT of Delhi remain whether they were prior to the special status conferred on the Union territory or the amended constitutional provision that has transformed Delhi in Stills Pran into the cells. Stop.